It allowed us to get all the bugs out, making a very simple question, and you didn't have to get into the merits of your argument yet. Okay, we have everyone on board. Counselors, please proceed.
Thank you, Your Honor. Good morning, and may it please the court. Elisa Yarnell on behalf of Raymond Building Supply, the appellant in this matter. Just 3 years ago, in the Edwin Taylor decision, a panel of this court stated that the construction lien laws were enacted for the protection of those who improve real property and are not sympathetic to a party seeking affirmative relief unless the party strictly complies with the provisions under the laws. Raymond, in this case, improved Venice Golf's real property. Raymond complied with the lien law to place a valid lien on that property. The trial court invalidated that lien on the sole basis that Raymond never responded to a demand that it never received. The plain language of the applicable section of the lien law does not support that result for two main reasons. First, the last sentence of section 713.16.2, which is the section that governs a demand for sworn statement, clearly states that the failure to respond to the demand has no effect on the validity of lien rights if suit is filed before the demand is received. And second, the language in section 713.18 governing general service rules in the lien statute does not replace the received language in the specific applicable statute.
And Ms. Yarnell,
Yes.
your position is that last sentence of 713.16 is basically a narrow exception to everything that's come before it in that paragraph, correct?
Yes, Your Honor. Our position is that that's one of several exceptions actually that are listed in the second half of that paragraph.
Sure.
So if you look at the structure of that paragraph, it begins with the obligations or, the option, and then the obligations that are placed on the owner, where the owner can make a demand for the sworn statement, and then the lienor is required to respond. And so those obligations on the owner are instructions on what the demand should include and how the demand must be served. And so that's what the owner must do. And then there are 5 separate sentences that cover different scenarios as to what happens if the lienor does not respond. And so what happens if there's improper service and the lienor does not respond? What happens if the lienor just simply doesn't respond for 30 days and that's the only condition that's present? What happens if the owner serves more than one demand? What happens if the response is incorrect due to negligence on the part of the lienor? And then finally, the circumstance that is present here, what happens when a foreclosure case is filed before the date that the demand for the statement is received by the lienor? And so just based on that structure of the paragraph, in order to give meaning to all of these sentences, they have to be understood as just describing different scenarios, and the specific scenario of the foreclosure case being filed before the demand is received operates as an exception to the more general situation where there is a failure to furnish the response and 30 days has elapsed. And so that's really what the plain language of that paragraph and of that sentence is stating. And so in that scenario, what the statute says is that the failure to respond does not affect the validity of the lien. And so what that means is that the lawsuit would go forward on its merits regarding the validity of the lien and any potential defenses that the owner might have against that lien, which in this case, Venice Golf never raised any other defenses and did not have any. And so the lien should have been enforced and remained valid. A few points about section 713.18, which the trial court relied on, although that didn't really form the focus of Venice Golf's argument here, is that 713.18, as written at the relevant time period, applied to instruments. not to documents. And a demand is not an instrument based on the plain meaning of the word instrument in the dictionary definition in Black's Law Dictionary of that term. A demand is something that asks for something to happen. It doesn't define rights or duties or liabilities. And so as written at the time, it really just didn't even apply. But even if it did, it defines what service is, not what it means to receive something or to not have received something. And so the language in 713.18, regardless of how it might apply to service or when it might apply, is not going to apply to the received language at the end of section 713.162. So just responding briefly to Venice Gulf's interpretation they put forward in their brief, and I expect that the court will hear more about that in a minute. But it really reads into that last sentence, limiting language regarding the time period that just simply isn't there. And in doing so would create kind of an absurd result based on happenstance. You have a situation where the lienor has no knowledge that there's been a demand that's been mailed at all because they haven't received it, and that fact is undisputed on the record here. And then
I wanted to make sure, Ms. Yarnell, there's no issue whatsoever that the notice, I mean, because you had proof that it was never received. At least this takes this equation out of it in this case.
Correct. In this, on this record, there's no dispute as to that fact. And so what Venice Gulf's position would say is that if Raymond had happened to file suit on day 29 after the demand was mailed, and so the 30 days had not elapsed yet, that would somehow preserve the lien in a way that filing suit on day 31 or 45 would not. And that's not based on a deadline that a party can have knowledge of, because in this situation, Raymond had no knowledge that anything had been mailed and that it was supposed to be receiving anything that was, who knows, lost in the post office system. There's no indication on the record as to what could have happened to the mailing that was not received. And so that absurd result is not what you actually see in the plain language of 713.162, where there is no limiting language that says a foreclosure suit filed within 30 days after service does not affect the validity of the lien. That last sentence is indeed much broader than that. And so, that this case, from our perspective, it is very simple in that regard with respect to the plain language of the statute and the structure of the statute. Unless the court has any further questions regarding our arguments or the record, I will briefly conclude. The statutory language. Go ahead, Your Honor.
No, I didn't see anybody from my screen having any questions. So I'll let you, I didn't know if you were concluded or not. That's my thought I was going to do it. But if you were about to speak, as they say.
Just briefly, Your Honor, the statutory language here is unambiguous, and the trial court in its summary judgment order ignored the applicable language and erroneously held that Raymond was deprived of its lien. And Raymond respectfully requests that that decision be reversed and that Raymond be able to proceed on its lien foreclosure case that was filed on the merits. Thank you, Your Honors.
May it please the court. I'm Ryan Owen of Adams and Reese LLP. We represent the Appaleve and the Scoffin Country Club No. 1 Inc. I'm going to first address section 713.162. On July 27th, 2021, Veniskoff served Raymond with a request for a sworn statement of account. For purposes of the motion for summary judgment, Veniskoff admitted that the request was not received by Raymond. However, through summary judgment evidence, Veniskoff established that Raymond's non-receipt of the request was through no fault of Veniskoff. Raymond didn't respond within 30 days. Under section 713.162, where a liener fails to respond to a request for sworn statement of account within 30 days of the request, the liener is deprived of its lien rights. And I just want to break down some of those 5 sentences that opposing counsel mentioned during her argument. The first, and I'm going to omit some of the words that aren't relevant. The owner may serve in writing a demand of any liener for a written statement under oath of his or her account. Next, a few sentences later, it states, the failure or refusal to furnish the statement does not deprive the liener of his or her lien if the demand is not served at the address of the liener or directed to the attention of the person designated to receive the demand in the notice to owner. Now, if there were a receipt requirement, this is the sentence where that would be present. And there's no receipt requirement because the statute specifically refers to service and designation to received, not receipt. The next sentence states, the failure or refusal to furnish the statement under oath within 30 days after the demand deprives the person so failing or refusing to furnish such statement of his or her lien. So at the point where the response was not served within 30 days of the request, that's when the lien rights were deprived from Raymond. And there's nothing in the last sentence of section 713.162 which resurrects lien rights which have already been deprived from the lienor. Accordingly, the lower court properly entered summary judgment.
Mr. Owen, so in your view, what is the point of the last sentence?
So the point of the last sentence is for situations where a lien foreclosure action has already been filed and there's counsel representing the party, but the statute still provides that the request for sworn statement of account goes to the lienor. And this would be a situation where if you had a counsel who was creative in trying to defeat the claim of lien, even though it had already been filed, even though notices go to lawyers at that point, a lawyer or the party could serve a request for sworn statement of account when there's a case pending. And the point of the last sentence is when there's already a case pending, you don't have to respond to a request for sworn statement of account. If you don't respond,
Why doesn't it just say that? I mean, wouldn't it be so much simpler if it just said, once the foreclosure action is pending, the lienor need not respond to a demand? And instead we've got what's written, which is an oddly worded. It's an odd reading, I think, given the way that this is worded, to interpret it the way you're saying. Because it's not saying, it doesn't say that it doesn't say that the rules have changed once the foreclosure suit's filed. It would be very easy for it to say that in some way or another, but instead it says what it says, and it specifically uses the phrase before the date the demand for statement is received by the lienor. And we can't ignore that language. There must be some significance about that language.
Your Honor, I think the significance is that it's possible for the request for sworn statement to be mailed or served before the lien foreclosure action is filed, the lien foreclosure action to be filed while it's in the mail, and then for the request to be received thereafter. I think it's worth mentioning that Raymond is not contending that it actually received the request for sworn statement of account. What it received was a copy of the request for sworn statement of account via email. And under section 713.18, there is a distinguishment between the original and a copy. So it's worth mentioning that we don't even have the circumstances that are contemplated here by the statute. There's no
So,
requirement
Let me ask
of,
you to look at the language again on of step 2 says the failure or refusal to furnish the statement. A refusal sounds like I am not going to do it. There's a scienter component, if I can borrow that phrase from criminal law. I have it and I'm not going to give it to you. That's a refusal. Now, the word failure seems also to contemplate receipt, but that they failed to comply to some form of dereliction of duty or negligence. It seems both those phrases, one could legitimately infer that the document was in hand. Is that a correct interpretation of that language?
it is, I don't think it is, Your Honor. I think it is as to refusal, but not as to failure.
Aren't words known by sometimes by the company they keep?
I think there's a reason why the legislature chose to use both. If they had just used refusal, then your argument would be appropriate, but where there's no refusal, where you don't receive it. But the legislature has elected under 713.18 to allocate the risk of something being lost upon the recipient. And if the notice to owner mailed by Raymond at the beginning of the work, within 45 days of their first furnishing materials, had been lost in the mail, and Venice Golf and Country Club had never known that Raymond was supplying materials, had never known that there was an address where they could send a request for sworn statement of account, then that risk of loss would have been on Venice Golf. And that's
Well,
the
Mr.
legislature's.
I think, I'm sorry, did you say that the risk of loss is borne by the owner or by the lienor?
I'm saying it's borne by the recipient of the
By
instrument.
the recipient, but that's only true as of 3 if 3 applies, right? Because when you talk about service under 1, service is affected A, by actual delivery to the person to be served, or B, by common carrier delivery service, et cetera, and with evidence of delivery. So at least under 1, apart from C, which is, you know, if A or B can't be accomplished, it's not just a matter of tossing it in the mail to affect service. There's got to be actual delivery or sent by common carrier with evidence of delivery. So I disagree with your suggestion that it's really just all this sender has to do is throw it in the mail, and whatever happens after that is on the recipient. Do you disagree with that?
Yes, Senator, I do. Under 3A1, there are requirements that it has to be sent to the last address shown or the last address known of the person to be served, and it has to be deliverable or not delivered or deliverable through no fault of the person serving the item. Also, elsewhere in 713.18, it discusses using certified mail and keeping records in order to track. And that's what Venice Golf did here. It mailed the request for sworn statement of account via certified mail. It kept a record, which is part of our record on appeal of the certified mailing number. It had that receipt stamped at the post office so they could track when the post office received the request for sworn statement in the envelope with the green return receipt card. And it is established by the affidavit of James Schell that this was one of more than 30 requests for sworn statement of account that were all sent out on July 27th. And the legislature has elected to put the risk of loss in the mail on the recipient. And that's because there are a large number of these mailings in the construction industry. Notices to owner can be sent out to hundreds of different parties a day. And there are services that are hired to do this. And if every owner had to track, or every contractor who's sending out a notice to owner had to track and make sure that each one is delivered in order to preserve their lien rights and possibly send things multiple times, that would create a large burden on the sender. And the legislature has elected to avoid creating that burden on the sender and have a presumption of receipt or a risk of loss presumption that falls on the recipient if it's through no fault of the sender. And that applies in this circumstance. Because
So the
otherwise,
document is an entity that doesn't know the document's coming, that has never seen the document, is unaware of the document, and has not received it, bears a risk of loss.
well, there's a risk of
That's
loss
what
of your
you're
lien
saying,
rights.
Is that the owner in this case can put in the mail, and the party to whom it's directed doesn't know it's coming, has never seen it, never touched it, never had it in possession, and bears a risk of loss. And that's that's the theory that we are proceeding under, that the legislature placed the risk of loss on the person who's never had any physical control whatsoever of the instrument.
Yes, Your Honor, that's what the statute says. And it cuts both ways. It doesn't just favor the owners. It favors the contractors more than the owners, because the contractors can also serve notices to owner. And if we don't receive it, we are still deemed to be on notice that the contractor is out there performing work and that we are supposed to look for their partial lien releases. And if we don't look for their partial lien releases, we make improper payments. The contractor can also serve a demand for sworn statement of payments. And if the owner doesn't respond.
713.18.1, as Judge Rothstein Yocum pointed out, service of notice, one, made by one of the following methods: A, by actual delivery. A notice to owner, by definition of the term, is a notice. And 713.18.1 says service of notices must be made by one of the following methods: A, by actual delivery, by common carrier under B, and with evidence of delivery. All those sound like receipt. If I read the statute correctly, I was just using the phrase you used, notice to owner. Well, notice to owner by definition, wouldn't that be a notice under 713.18.1? And doesn't 1A and 1B, those two actually require delivery to be made? That's why I'm having problems saying the risk of loss is on the person who's never had control.
So what 713.3A says, and if you only read 713 or 713.18.1, you don't get there. But 713.183 also exists. And we can't completely ignore its existence. And what it says is service of an instrument pursuant to this section is effective on the date of mailing of the instrument if it, one, is sent to the last address shown in the notice of commencement or any amendment thereto, or in the absence of a notice of commencement to the last address shown in the building permit application, or to the last known address of the person to be served. Now, the first two things there, obviously those are services things going to the owner. It's only the third that it's the last known address of the person to be served, which in this case would be the liener who gave their address in the notice to owner. And two is returned as being refused, moved not forable, or unclaimed, or is otherwise not delivered or deliverable through no fault of the person serving the item. So 713.183A2 contemplates service being effective even if it's not received. And that is what places the risk of loss on the recipient of the mailing. Now, I understand
How
that
does your client prove
That's case,
that the
then
last part of
doesn't the
statute has been met?
I'm sorry, Judge
How does your
Castaneda.
client prove that it was not deliverable through no fault of you serving it? And if this is not strict liability or res ipsa, that it didn't get returned, you have to prove it's through no fault of your own. How do you
Right.
prove that?
So in this case, we proved that through an affidavit in support of the motion for summary judgment that established that the envelope was properly addressed. It had the proper
That's
amount
not
of
gonna do it.
postage.
You got to prove why it wasn't returned and why it was not returned through no fault of your own. You're proving that it was placed in the care, control, and custody of the United States Postal Service. That is different from not deliverable through no fault of your own. So tell me, how do you prove it's not deliverable without tracing that and finding it or finding what happened to it?
So, Your Honor, the Postal Service creates an electronic record of the mailing based upon the certified mail return receipt number. And you can go to the post office website. We did this and attached a copy of it to our motion for summary judgment, showing that it was received by the post office and it was still in transit as of the time that the motion for summary judgment was filed more than a year and a half later.
So so it proves it's still in transit. Does that prove it's not delivered?
The the plaintiff's affidavit, Raymond's affidavit, proved that they had not received it.
That doesn't
And-
prove, does that prove that under the statute that it's not deliverable? It's still in transit. If it's still in transit, according to the Postal Service, how is it not deliverable? And you ought to know that for 89 days, I worked in the post office, so I have some idea of the inner workings, but that was 40 years ago, so don't worry about it. I'm just saying, if I'm looking at the statute and the post office said it's in transit, how does in transit mean the statutory term not delivered?
Well, the statute actually says delivered or deliverable. So I'm relying on the delivered and the affidavit in opposition to the motion for summary judgment saying that it was not delivered.
So you're saying it was not delivered and through no fault of you who served the item, is that correct? So make sure I got the statutory language correct. Got
Yes,
it.
Your Honor, that's correct.
Got it.
So I think we've established now that there has been service as required by 713.162 in order to trigger the 30 days running. Now that 30 days ran, and at that point under 713.16.2, the lien rights were forfeit. So they're gone. Now, and that happened in August of 2021. So then we wait until July of 2022, and that's when the foreclosure action is filed. At that point, the record evidence establishes there was an email to opposing counsel with a copy of the request for sworn statement of account. Now, an emailed copy is not it being delivered. So there's nothing that happened at that point that would trigger the last sentence of 713.162 and say, at this point, you've received it and there's no effect if you don't respond. So I think that I'm reading 713.16 sub 2 properly, especially with 713.18. I know opposing counsel has argued that a request for sworn statement is not an instrument, but notices, claims of lien, affidavits, assignments are all instruments, and they are permitted or required under this part. It makes sense to me that a request is also an instrument. I think it would be silly for it not to be. Now, opposing counsel has filed a notice of supplemental authority, and I want to point out that that is of no moment under the Florida Supreme Court's holding in Parole Commission versus Cooper, 701 Southern 2nd 543, and State Farm Mutual Auto Insurance Company versus La Forêt, 658 Southern 2nd 55. It is inappropriate to consider a statutory amendment to determine the legislative intent regarding the original statute. The only exception is not present here, and that's when it's in response to a specific recent controversy. Also relevant is Knowles versus Beverly Enterprises, Florida, Inc., 898 Southern 2nd 1. It's a 2004 Supreme Court case where it was held where the legislative history is silent as to why a particular change in question was made. An amendment is of no moment to the issue. So I'm happy to answer any other questions that the court has. But I think it's very...
Carolyn? Yeah, I've got a question. Under
Yes.
3A, if your that service can be affected even if there is no receipt. And as a general rule, the recipient bears the loss of receipt under 3. Then isn't it all the more significant that the legislature used the phrase before the date the demand for statement is received by the lienor? And it specifically used the word receipt. It didn't say service. So doesn't that make that language more significant?
I don't believe it does, Your Honor. I think what matters is the word effect. And it having no effect where the lien has already been deprived by the failure to respond almost a year before the suit was filed. Because otherwise, let's take this to its logical conclusion. If a owner, and let's say it's a huge project like Disney World being constructed for the first time, and there's one general contractor being hired to construct the entire park, and they have hundreds, if not thousands of subcontractors, and all of them are serving notices to owner in order to protect their lien rights. And there is a dispute between the owner and the contractor that leads to Disney serving a request for sworn statement of account on all of the hundreds, if not thousands of subcontractors who have served notices to owner. Under the interpretation put forth by opposing counsel and Raymond Building in this case, Disney would have an affirmative obligation. And I just realized I chose a horrible example with Disney and our current governor's fight. But despite that, they would have an obligation to trace down the hundreds, if not thousands, of recipients of those requests for sworn statement of account and ensure that each and every one of them was delivered. Otherwise, they could be subject to a claim of lien being foreclosed months, if not years down the road. That's not what the legislature intended. They intended, with the last sentence, to prevent a gotcha technique by owners whose claims of lien were already being foreclosed, serving requests for sworn statement of account in order to terminate lien rights that were already being foreclosed. Or if there's on the eve of the dispute, the legislature did not intend to create a requirement that eviscerates the general rule that no receipt is required and places a huge potential burden on people to make sure things are delivered.
I need to advise you that you have passed the 20 mark. The good news is you're the last case of the day. And it's interesting. So I'll let you go on. I just want to let you know that I may have to give time to balance out at the end. And I didn't want it to come as a surprise because we're at 22 now. So you probably ought to proceed towards summing up.
Thank you, Your Honor, for calling this interesting. I think that's the first time that statement's been made. So in conclusion, the lower court's entry of the final summary judgment should be affirmed and Veniscoff's motion for appellate attorney's fees should be granted. Thank you.
Well said, but it's still interesting. All these statutory interpretation matters and all the things I learned or they tried to instill into my brain at the University of Virginia program on the course of legislation, which was one word instead of two, statutory interpret. Like it's coming back 20 years later and I'm having to go way back in time. So with that said, counsel for the appellant, Ms. Yarnell, instead of the 5, you have 7. And I balanced it out as best I could.
Thank you, Your Honor. Just a few points that I'd like to make in response to some of the questions that were asked and the points of Veniscoff's counsel. First, regarding the notion that this is essentially a risk analysis and a risk allocation. This is a situation, and Judge Casanova, you pointed this out very, very succinctly and clearly, that this is a situation where a demand is served and there is no possible way for the contractor lienor to know that this has happened until it is actually received. It's not a document that's been recorded. It's not a document that's been filed with the court. There is literally no way for them to respond until they actually receive it. And so that's different than some of these other documents that might be served under the service statute where it is, a lien has been recorded and the owner can see that in the recording records that document is there. And so that's different. It's also different in that it is the demand that triggers a deadline to respond to it. But that fact that it is the demand that triggers the 30 days to respond raises the second point that I would like to make, which is that even the language of that sentence that gives 30 days to respond is not worded the same way as as the other language in the service statute. So I'll quote, the failure or refusal to furnish the statement under oath within 30 days after the demand deprives the person so failing or refusing to furnish such statement of his or her lien. It does not say within 30 days after service in that sentence. It says after the demand. And so that's
No, it also doesn't say within 30 days after receipt. So isn't Mr. Owen's position well taken that what you're effectively trying to do is amend that sentence of the statute?
I don't think so, Your Honor, because I think in essence, it's the last sentence that's really being operative. We don't need to change what the earlier sentence about 30 days says. But the point in stating that this sentence doesn't say service is that there's not some concept that service happens and then 30 days there's this automatic poof, the lien is gone if you don't have if you don't have any way of knowing that it's actually happened. So you know, I think it's a bit ambiguous as to what happens if, you know, if the service is received by the lienor on day 28 or day 30 after it was sent, and then, you know, what happens in that situation. The statute doesn't really seem to address that point. And Judge Casanueva made a similar point with respect to the language of failure or refusal, which also contemplates that something has actually been received and it would be possible to respond to it. And even in Venice Golf's brief, they admitted that there's no expectation that Raymond could respond to a demand that hasn't been received. Why is that? Because it's impossible. That would be an absurdity, which is not how courts interpret statutes, to create an absurdity that just simply isn't there based on the plain language. And so that's where we just continue to fall back on the last sentence, which just says that if the foreclosure case is filed before the date the demand for statement is received by the lienor, then the failure to furnish that response does not affect the validity of that claim of lien. It just simply has no effect, and the case can proceed on the merits as they otherwise are. And Judge Rothstein-Joachim, your point about the received language being so significant in light of the exception in 713.183A that wouldn't require receipt under some circumstances. I think that really underscores that the legislature recognized that it was creating a bit of an anomaly otherwise in requiring service of something that there would be no other knowledge of. And so if the lienor is being proactive in foreclosing on its lien rights, then the lack of receipt is not going to affect the validity of that lien. And unless the court has any further questions, we would respectfully request that the trial court summary judgment decision be reversed.
Thank you both. Thank you for your patience and the quality of your presentation today. Appreciate it very much. I didn't mention to you earlier that you guys are not the only ones that may be having sound problems. Earlier today, it looked like I was screaming at everybody and everybody was screaming at me. So I was adjusting my sound, and I meant to give you my disclaimer. I'm not screaming. I just don't know what my sound level is coming across over there. When I did the first warning on OAs today that you were at 15, nobody heard me. So if anything came across loud, I doubt that it was intended to come across anything other than, I hope you hear me. I appreciate your patience and everything. What do they say? You'll hear from us.
Thank you both.
so much. That will conclude our oral argument today. I will let you exit back. There's nothing remaining on our docket. So if you wanted to watch something, it's got to be what preceded you. Stay well. We hope to see you soon.
Thank you, Your
Thank
Honors.
Thank
Thank
you, Your
you.
Honors.
Bye-bye.